Welcome to Real Estate and Loan School. We're so excited to share with you our method, which has been time tested and it works. What we've done is that we have read the books for you, took the notes for you, and connected all the dots for you so that real estate is easy to understand. Now let's sit back, relax, and enjoy the class. Now let's look at what it takes to get your license. We want to make the next 3 months your priority. Make sure you set aside time for homework and taking the quizzes in the textbooks. You want to finish all 3 final exams in the next 3 months. Be persistent and focused. The tips on reading the book is that you first begin reviewing our notes and outlines first to get a good grasp of the topic. And then you skim over the chapter. Use the chapter as a reference source if you missed a question. Now remember, try to score the quizzes at 90%. We will go over more in detail in a few minutes on this one. The last part is REL's duties and responsibilities. REL is not a tutorial center. We're not a placement agency. And we're not a career center. We are a course provider approved by BRE. Now let's look at in detail how to study the textbook. The REL's notes and outlines are based on 90% of the principles book, 80% of the finance book, and 60% of the practice book. That's because the practice book is much more hands-on with sales and marketing, which is not on the state exam. Now, some of the tips of studying the principles and finance and also the practice textbooks. We will begin with the principles book, textbook first. Remember to always review the notes first, our notes, and then read the summary, the end of the chapter, at which point you also have what is called practice application. That is optional. You don't have to do that one. Take the quiz at the end of the chapter. If you miss a question, then go back to that chapter to get some answers why you missed it. There's also 150 questions at the end of the textbook, the principles textbook. And you will do this only when you are preparing for the final exam, for the principles exam. On the finance textbook, you do the same thing as the principles book. Again, now finance does not have 150 questions, but REL will guide you step by step when you do the finance and practice textbook on what to do with that. I hope this helps. Now let's look at the final exam instructions, and we'll go over that quickly now. Let's go ahead and look at this. When you finish our last session, REL will send you a separate email, which is called What to Do After Live, and that we will enclose final exam, test administrator form, and answer sheet. It is an open book, 2.5 hours. Do not write or mark on the exam. The test administrator, which is your proctor, cannot be related to you by blood. And that proctor must sign the test administrator form for you. The answer sheet, when you answer your questions, be sure that you fill in the bubble, but do not put an X on the bubble. Keep on going here, right here. Now you need to go ahead, when you finish, you mail the following forms to REL: the final exam, the answer sheet, and the test administrator form. You mail it to REL address. The passing rate for this final exam is 60%, but remember the state exam is 75%. When you pass, REL will email you a certificate. If you fail, then we will notify you that you need to retake the exam. Again, there is a 2.5-week waiting period, and there will be a $25 re-examination fee, and you have to wait again for that waiting period. REL is not allowed to discuss missed questions with the student after they have taken the exam, because this is BRE's guidelines. And we will also go over the expiration date of the courses. You have 1 year to complete all 3 courses, and your instructor will give you your expiration date. If you do not complete all 3 courses by the expiration date, you can have a one-time re-enrollment fee of $100, which will extend 3 more months for you, and you can complete the other courses. Now let's look at the table of contents and what is expected of you in the homework. Notice on the table of contents you have 4 weeks, which is really 4 sessions. The textbook column that corresponds with the live sessions, and the page numbers are the notes, the REL's notes. Your job is to go through each chapter as assigned. Again, do the back of the quiz in each chapter, and check your answer and make sure you score at least 90% on each one. Again, look at session 2, the live sessions corresponding with session 2, the textbooks, and again the REL's page numbers corresponding with REL's notes. You do this with 4 sessions, and REL will send you separate emails to remind you this particular assignment each time. Now let's talk about personal property. Personal property is either tangible and intangible. Intangible items are called chattel real. Chattel real are documents with real estate interests, like mortgage, lease, trustee. Tangible items are called chattel. These are like automobiles, money, furniture, jewelry, and so forth. The other part is trade fixtures. Trade fixtures are business. Anything to do with business is personal property. For example, if you have a manufacturing firm who leases a building, and the company installs an air conditioning unit on the wall. Because he is in business, when the lease is over, he can take that air conditioning unit with him. And that is, again, under the category of personal property. Last thing is emblements. Emblements, again, is business. But this is on agriculture. So if, let's say, someone leases a land to plant corn, and corn is for the business of selling and harvesting corn to sell. Once the lease is over, he can take the corn, even the seed in the ground, because he is in business. We'll discuss more in class on personal property. Let's talk about real property. Real property is land. It's affixed to the land, it's appurtenant to the land, and it's immovable by law. Appurtenant to the land really means that anything that you have, when you sell the property, it runs with the land, it goes to the new owner. Let's go ahead and look at the first test of real property, and it's called the test of fixtures. Test of fixtures, the acronym is MARIA. MARIA is, first, M stands for the method of attachment. Method of attachment means anything that is bolted, cemented onto the wall, it goes with the land, so it goes with the property. So when you sell it, for example, an air conditioning unit that's it bolted onto the wall, when we sell it, the new owner, the buyer, will also have that air conditioning. Adaptability, is it customized? if a drape or something, even carpeting, if it is adapted, if it's customized to the property, to that particular window or floor, then it goes with the property. The relationships between the disputants. So seller and buyer, let's look at who the court favors. Seller and buyer, the court will favor the buyer. Landlord-tenant, the court will favor the tenant. Borrower and lender, the court will favor the lender, because B of A always wins. The intentions of the parties, agreement in writing and in oral. Now, we will talk more about agreements and so forth under contract. And then the agreement, again, agreement meaning your listing agreement in real estate. Now, let's look at bundle of rights. Bundle of rights means when you buy a property, you have all these rights with you. The first one, again, the acronym is puede. So P stands for possess. You have the right to possess and live on the property. You have the right to use. Now, you can use the property according to the city's ordinance. In other words, if the city allows you to have this is a residential or commercial or mixed property, that will be according to the county or the city. Encumbrance. Encumbrance means burdened. Anything you burden the land. Now, borrowing money is one of them, but there are many types of encumbrances, which we will talk about later. Disposing, you have the right to sell or will it. And finally, excluding. Excluding means you have, like a gated community. You can actually exclude certain population because you have a gated community. Let's keep on going. And the last one would be here. We talked about appurtenance run with the land. But I have put a chart for you to show you the difference between personal property and real property. Notice, personal property, you can take it with you, right? Trade fixtures, we talked about anything to do with business, you can take it with you. Implement, anything to do with season crops or agriculture, you take it with you. Let's keep on going to the real property. Real property, again, it stays with the land, which is called appurtenance. Water heater, you cannot because it's part of that property. If you have a tree rooted in the backyard, you cannot take that tree with you. When you sell it, it belongs to the new buyer. What you want to learn is this one right over here. The difference between stock certificate and stock in mutual water company. What that means is this. Stock in mutual water company is some areas, most of us, we get our water from city or county, but there are some areas like Santa Cruz, they actually have to buy water from a private company, and they buy stocks, and those stocks are from the mutual water company. That is a private company, and when you sell your property, the new buyer also has the stock in mutual water company. The difference is that the stock certificate is the stock that you buy in Wall Street, and that's why it's personal property stocks. The state exam will trick you with these two words, and you need to know the difference. This ends real property. We're still continuing with real property, but this time we're going to talk about water rights. Let's go ahead and look at the slide right here. Right over here, water rights, okay? There are several types of water rights. If you live next to a river, you have riparian rights. You live next to a lake, you have littoral rights. There is also a word called appropriation. What that means is this. Let me give you a picture of that. Okay, let's say that your neighbor here lives next to a river. So he has riparian rights. okay? Now, but you are living on the top of the hill and you have no water. You need to get down to the end of the hill to get the water. You need permission to get the water. And you cannot, who you ask is that you ask the state permission. The state will give you the permission and the state will give you appropriation right, so therefore you can go down the hill and get the right to get the water. Now let's come back over here again, and there's some terminology you might want to learn about this, and I'm going to pull this one just a little bit up, okay, right over here so you can see everything. So let's go ahead and look at these three words right over here. Land taken away by nature. So these are words like erosion. Erosions are natural phenomenon. For example, a beach, the wearing away of the sand of the beach, that would be erosion. Accretion is building building the land by form of volcano or landslide. Alluvium is the soil that is deposited through accretion. Avulsion is the disaster such as earthquake or hurricane and so forth. You also have a word called percolating water, which is not on the screen right now, but percolating water means that the water it's not confined to a well, it's just moving all over the place, and the law says that it allows the beneficial use of such water, and you know, it's just a definition of what that is. It's not a well, but it's not confined to a well. Okay, the last part of real property is land taken away by man. I'd like you to go ahead and look at the slide over here. Land taken away by man can have two ways. You can have eminent domain or police power. Eminent domain is a private property taken away for the benefit of public use. For example, if the city wants to run a highway through your street and your house, they will compensate you with some sort of fair market value, and then you will have to move. The thing with police power is a little different. Police power is for the health and welfare and safety of the neighborhood. And what that means is that if you are, let's say your neighbor has 50 cats, and you really, I mean, the whole place is a mess, and you call the police, and police power will come in, and they will condemn the house. You do not lose the property, you just have to clean up the property. The difference is that you do lose the property on eminent domain, but police power, you just have to clean up and you resume whatever you're doing with your own property. There is one more on the handout, and it's called escheat. Escheat is, if let's say there's a property that they have no heirs to inherit the property. You have a 5-year period, and the state will look for someone to take over the inheritance. But if they cannot find it, then it escheat back to the state. We will talk a lot more about that in another chapter. We're now on the chapter of land descriptions, and let's go ahead and identify those 3 types of land descriptions. There are 3 types of land descriptions. One is lot, block, and tract, which most of us have. And then you have meets and bounds. And the third one is called township. We'll talk about this in more detail, but let me show you the first 2 right now. Let me show you a slide on tract, lot, block, and tract right here. Let's say you have a home and you are right over here. So the county has to describe your property. Remember, it's tract 2025. You are in the block of A, and you're right over here, number 4. So they have to describe what it is. And this is the description right here. right over here is the lot, block, and tract. Lot, block, and tract is all of Lot 4 and Block A of tract number 2025 in the city of Bellflower, Los Angeles County, California. That's what it will look like in public record. Now you have meets and bounds. Meets and bounds are more prevalent in rural areas. Now look at the description and tell me what would be the flaw of meets and bounds. Look at this one. Beginning at the stop sign on the northwest corner of 4th and Main Street. Thence 100 feet due west to the redwood tree. Thence 120 feet due north. What would be the disadvantage of this in this description? The disadvantage is the redwood tree. If the redwood tree has been chopped down or fall, whatever, then your description would be distorted and it would not be a relevant description of the property. Now we're going to talk about township, how township works. Let me show you a picture of how township is divided. Right over here you have a map of California. You need to know that the meridian line is a vertical line and the baseline is a horizontal line. That's what you need to know on the state exam. Of course, it's divided into 3 sections. Okay? That's all you need to know, the baseline and meridian line. The next thing is over here, township. Notice, township has 36 squares. And let's go over the measurements of each square. Just remember, 36 squares, each section is 1 mile by 1 mile. One township is 36 square miles. Okay? And one section is 640 acres. 1 acre equals 43,560 square feet. This is the state exam, but before we go into that one, I want to show you you got to be careful, the 2 wordings, the difference between mile square and square miles. Notice, if the last word is square, you double it. If the last word is miles, you don't double it. For example, if 2 miles square, you double it, it becomes 4 square miles. Notice again the last word, miles, and you count how many you have. Now look at the other one, is right here, right over here. Now what happens if you have 3 miles square? Again, the last word is square, so you have 3 miles square. You double it right there. And then you have 9 square miles. The last word is miles. Okay? Now let's go on, keep on going. Here's your benchmark right over here. So, you have 1 mile square. 1 times 1, 1 to the first power is still 1 square miles. One section is 640 acres. Every little section is 640 acres. But this exam is going to say, what about I only want 1/4 of that section? So what you do is that, notice the last part right here is 4. You just go 640 divided by 4 and you have 160 acres. What happens if the exam says 1/4 of 1/4 of a section? You just look at the bottom number 4, so you go 640, 4 times 4, 16, divided 640 divided by 16, and you have 40 acres, and that's how you arrive at that number. What we're going to do in class in a few minutes is that you will see this page with all these questions. These are all the questions. You have the answers in front of you. Try to cover the answers, and then we'll work in pairs. We'll work in pairs, and we'll try to answer these questions as we just talked about. Okay, now we're on the chapter of acquiring title, and there are many ways that one can acquire title. Let's look at the slide right over here. And one of them is you acquire title by transfer by accession. Now we talked about this, transfer by accession. Okay, let's go ahead and do Just one more, okay. Transfer by accession is that, remember we talked about nature? What nature can actually gain soil by accretion, or worn away or disaster by erosion or avulsion. So that is the acquiring title by nature. But man can actually acquire title as well. For example, if your neighbor builds a fence over to your property, he has actually gained a few feet of your property that will now become his. So that would be by man. What I want to talk about are these two right over here. Acquiring title by occupancy. By occupancy is either prescription or adverse possession. We will talk more in detail next week, but I just want to introduce to you what these two are. They are very important to know. Prescription is use. Remember, the key word is use. So let's say your neighbor has a side gate that goes to the beach, and you use the side gate to get to the beach. Now, the open possession is open, meaning the owner sees you. That's an open. The other word is hostile. Now, hostile doesn't mean he has a gun. It means that he sees you and he doesn't do anything. And you continue to use the side gate for 5 years, then you have what is called prescriptive use. The difference now is adverse possession. Again, the difference is this. Adverse possession, you actually pay taxes, not just use. You pay someone else's taxes for 5 years, and we'll go over in detail what happens. How do you do that? Again, it's open. You see somebody using the property, or it's notoriously that you know somebody's paying your taxes. And now the problem with this one is because you pay taxes, you actually gain title. And because there are two owners on title, you have what is called a tainted title. And the tainted title is what's called cloud on title. Once you have a cloud on title, it runs with the land. That means when you sell it, you got a tainted title. And there's a problem of selling it because you have a cloud on title. This should end at this portion, and we will go over about deed in the next discussion. All right, let's go ahead and talk about transfer by deed. What exactly is a deed? Now, we're looking at a deed that is a grantor. You have to have a grantor or grantee. The grantor must be competent. He has to be 18 or over. The grantee must have capacity. That means he has to be alive. It's got to be a natural person or a legal person. Legal meaning a corporation have a deed. The criteria for a deed would be, it's in writing. Now, there are 8 criteria, but we're only dealing with 4 because those are the 4 you need to remember for the state exam. It's got to be in writing. It has to have a granting clause, meaning A grants this house to B. That's a granting clause. And it has to have a description of the property, and it must be delivered. Your instructor will give you scenarios, Q&A on this part of it, deed. I'm going to move on now to types of deeds, and let's go ahead and look at the types of deeds. The warranty deed, grant deed, trust deed, and quitclaim deed. Those are the 4 we're going to talk about. So let's go ahead and look at warranty deed. Right over here. Sorry about the mess, but that's something these are the notes that we have taken in the past. Now, warranty deed is this. Warranty deed is a guarantee deed. It's an express deed. What that means is when someone sells the property, now California, we do not have warranty deed. Let's say Texas has it, okay? If they sell the property, this owner is liable for before and after acquiring the property. There's a tremendous amount of liability involved in this. Now, right over here is a specific limited warranty. It means that if, let's say during the foreclosure times, Texas had a lot of properties that they have to go through foreclosure, or they buy foreclosed properties. And what they do is that they said, I don't want the unlimited liability. I want to have a specific limited warranty. That means I will only be liable for the time that I bought the property, not the time before, and only for this particular period, so that they want to not assume all liability. Now, right over here, grant deed is California. Grant deed does not want to have that full responsibility. So the grant deed gives the liability to who? To the title company. The title company is responsible for any liability, and we talk about what the title company insurance does and covers. It actually releases the burden of the owner. The grant deed has what is called an implied warranty, and it has an after acquired title. After acquired title means the grant deed has this feature, what is called it's autocorrect. Let's say there's a estate sale, and the paperwork hasn't really gone through all together, but they sell the property anyway. When all the paperwork gets together and it starts to be recorded, what the grant deed does is that with this feature, it will self-correct and actually make it better and better even after the new owner has acquired the property. Now, also too, it's called the trust deed. The trust deed in California, now California has trust deed. East Coast have mortgages, okay? Trust deed is really for the purpose of foreclosure. What that means is this. Before I go in, I want to what this means is this. If you are buying an all cash, you bought the property with all cash, you won't have a trust deed because there is no lender. This is to actually cover the lender. So there are three parties. You have the trustor, the borrower, the beneficiary is the lender, and the trustee is the third party. The third party, trustee, is appointed by the beneficiary to do the foreclosure sale. It could be a trust company, it could be an insurance company, whatever the beneficiary wants to appoint. Now, here it is. Once the trustor, the borrower, has a loan, he transfers to the third trustee a bare or naked legal title. The trustee does not have title until you actually default on your loan. That's when he comes in. That's why it's called bare, naked legal title. We'll discuss more about that and more examples of that. And the last one is quitclaim deed. Now remember, quitclaim deed removes, corrects any kind of mistakes. If you want to add a name, to a grant deed, then you must have a grant deed to add, and the quitclaim deed is to remove. All right, let's go on with transfer by succession. Now there are types of wills that you need to learn, and that's called holographic will, and that's all handwritten. A statutory will is a legal form that you can download it. It's a form that anybody can actually have. What I do want to talk about is the die with the will. Now let's go ahead and look at the transparency right here. Okay, let's go ahead and do this. Now, oh, it's right over here now, okay? Again, if a will needs only 2 witnesses. All right, now, if you die with the will, and somebody writes the will, the person is called a testator. The testator has an executor. An executor, he executes the will of the testator. The thing that you need to learn is this. If the testator leaves what is called real property, if he leaves real property, it is called a device. The devisor is the person who's writing that will, and the devicee is receiving the will. Now, he wants to leave a house, then this is called device. If he wants to leave a computer, it's called a bequeath. Okay? Well, what happens if somebody didn't write a will? Then if there's no will, it's called intestate. Once there is no will, it goes into a probate. It goes to probate, and everything is turned over to the court. The court assigns an administrator to go and sell the property. The sales price is determined by the court. Now, so the court controls the entire thing right here. What if they cannot find an inheritor? Now remember the word escheat? Well, it escheats to the state because, remember, there's a 5-year hold, and the state will actually take the property or something, the auction it to the highest bidder. But this doesn't really come in play if we don't have the inheritance problem. This is much more of just a will or not will. It gets a little more complicated than that. The last thing is that bequeath. Now on the state exam, they'll ask you which 3 words are real property. So personal property is called bequeath, right? Real property is device. Remember demise, that lease agreement? That lease agreement is personal property. And what is that called? Chattel real. Okay, we talked so many things about different types of transfer. This one is called transfer by title. So let's go over and look at the slide right here. All right, transfer by title. There's an abstract of title. You just need to know that, okay? Abstract of title means a record of history of all the title that's been transferred. Certificate of title is an opinion of the condition of the title. And guarantee of title is that it guarantees all losses resulting from public record. The title insurance that you pay covers these 3 things. It covers defects of record, it covers forgery of the title, and lack of capacity. In other words, if there is somebody who signed that was a minor and the title was transferred, then therefore the title insurance would cover that kind of mistake. The other 2 things that you need to know is called 2 types of title insurance. CLTA stands for California Land Title Association. It's also known as the owner's policy. Now most of the times the seller pays this policy. The ALTA, American Land Title Association, is really a lender's insurance. And that means if the borrower has a loan, the borrower, and now the buyer, has to have an ALTA policy when he makes his offer to the seller. It is also called an extended policy. Well, what happens if you have an all cash, no loan, you just pay all cash for the property? Therefore, the ALTA will not be applied at this point. Okay, this ends the portion of title insurance. All right, we're talking about the next one is the ownership. There are 2 types of notices. It's called constructive notice and actual notice. Let me show you a slide over here. You have constructive notice right over here, constructive notice. Now, constructive notice is when you have a constructive notice, you have 1 or 2 things you need to do. You either record or you take possession. Now, taking possession doesn't mean you move in. It means that you went and you inspected the property. You either inspect or record under the constructive notice. The second one is called actual notice. Actual notice means you have knowledge, but you really didn't get the property, but you have knowledge of someone else having the property. Now I have drawings and little animation here to show you how this thing works. Alright, so let's go ahead and look at the first example right here. Now you have a mother. The mother deeds to A, the son, and the mother deeds to B, the daughter. C is the neighbor. The neighbor overhears what the mother did. So the question is, what notice does A and B have? They have what is called constructive notice. And C has actual notice because he only hears it. He didn't really get, he was not deeded the property. So let's go over some examples, and I think this will be clear, and we'll talk more about that in class. The first one is if you have the son, A, and B is daughter, and C is neighbor. Now, here it is. Who gets the property? Son records, daughter does not record. A gets the property because A has constructive notice. He gets the property because he recorded it. C does not have the property because C has actual notice. He does not get the property, he just overhears it. He does not have that property. Now the second example will be right here. The son has a constructive notice, but he records. The daughter has constructive notice, but she, what is called take possession, or she went and looked at the property. Who gets the property? Well, B, because possession, inspecting the property, has priority because she has more incentive. She went to the property, inspected it. She takes the property over A. This last one is this. Last one is A has constructive, he records first. B, constructive notice, she records second. Who gets the property if both record? The first to record is the first in right. So A gets the property. One more, and this is this one. When do we get constructive notice? Whenever there's a transfer of ownership. And when do you transfer ownership? Number one is that you have a purchase. You transfer ownership. Can you transfer ownership to yourself? Yes, on a refinance. We, in essence, have already constructive notice. All right, we're starting a chapter called Freehold Estate, and we'll talk later on about less than freehold estate. Freehold estate, remember, is real property. There are two types of freehold estate. Right now, under here, freehold estate is either fee simple absolute or fee simple defeasible. Fee simple absolute means when you buy a property, most of us have fee simple absolute. You can do anything you want. You can will it, you can sell it, and it is indefinite. But fee simple defeasible has a condition on it. Now there are two types. The fee simple determinable is there's a condition before, and fee simple subsequent is that there's a condition after. For example, let's say over here, when you buy a property, the condition is that you're not to serve any alcoholic beverages. But when the previous owner walks in and sees you serving alcohol, then he can actually seize the property because there is a condition. The after is more of, I'll sell you the property if you turn it into a park. And that's the condition. If you don't turn it into a park, then the property goes back to the original owner. The third type of freehold estate is called life estate. Now, the life estate works like this. You do need to know the names of the parties. So, you have A, the grantor. The grantor grants a deed to the grantee for a life estate for the life of B. Now, if B dies, it reverts back to A, and A has a estate in reversion. It becomes a fee simple again. Now, he cannot will it because it's for the life of him, all right? Now again, the instructor will go over all types of scenarios and make this applicable to real life. The next one is estate and remainder. So let's say you have A again grants to B the life estate, but for the life of C. For the life of C. The C is estate and remainder. Now, meanwhile, life estate B is a grantee, and can sell, can lease, can will, as long as C lives. Once C dies, it reverts back to A, and A is the estate in reversion. The last one is leasing. Now, let's say A grants to B, B leases to C. C is just a tenant, okay? All right, now, if B dies, what happens to the tenant? The tenant's lease automatically terminates. It goes back to A, and A is an estate in reversion. And this ends the life estate. All right, we're in the chapter of less than freehold estate. Less than freehold is personal property. It's about landlord-tenant. So let's go ahead, look at the slide over here. The parties involved in less than freehold is the lessor, lessee. Lessor is the landlord, lessee is the tenant. Again, remember, whenever there's a lease agreement, it's personal property. It's chattel REL, personal property. So remember those words, they all come together. There are different types of tenants. Different types. First one is estate for years. And the estate for years has a lease. You have a termination date. Now, lease doesn't have to be 1 year. It can be 7 days. Whatever it is, there's a termination date. The next one is periodic tenancy. Periodic tenancy, again, if there's no termination date, it just keeps on going. It can be month to month or week to week or whatever. It just keeps on going. Now, if the landlord wants the tenant out for any reason, and if the tenant has been there more than a year, the landlord has to give a 60-day notice. If the tenant has been there less than 1 year, then it's 30-day notice, okay? Now there is a new law here, and that is AB 1171. During the foreclosed period, the landlord has to give a 1 year notice if there is a tenant that's 62 or over, years or over. A tenancy at will is, there is no agreement. If there is no agreement, such as a foreclosure scenario, and the instructor will go over that, then there is a 30-day notice. And the last one is tenancy as sufferance, which means that whenever a tenant defaults, the landlord, the lessor, always suffers from that. And we'll talk about how to get that money back. The next one is a type of leases, and this is mostly applied to commercial properties. Let's look at this right now. You have different types of leases. You have a gross lease, and the gross lease is a flat rent. The landlord pays for the taxes, maintenance, and insurance. Net lease also sometimes is called triple net lease. The tenant pays for the rent, insurance, maintenance. Mostly, a net lease is applicable to tenants who are long-term tenants, that they're going to stay for a long time. The percentage lease works another way. It's based on the percentage of sale. So the higher gross sale, the smaller the percentage. Lower gross sale, the higher the percentage. Which really means that if you're doing very well in business, you're less likely to default. So they give you a smaller, they'll charge you less on the lease. Graduated lease is much more of, we can start off with 1,000 and then we can graduate up or we can graduate down over the years. And that's the graduated lease. Now let's talk about what happens if the tenant, the lessee, defaults on his rent. What is the procedure that the lessor, the landlord, has to go through? Now, here it is. This is when the tenant defaults on the rent. Now here is a procedural thing, and your job is to know the names of these legal terminology. First of all, the landlord gives an eviction notice, and then he gives a 3-day notice, pay or quit. Okay? Again, there's a 30-day notice, a 60-day notice, depending on the year of how long the tenant has been there. We talked about that. If that doesn't work, then he goes and he files a unlawful detainer. Most landlord lessor hires an attorney to do that. There are eviction attorneys that only specifically do these evictions. So the name is called unlawful detainer, the landlord starts legal proceedings. The judge, it goes to the judge, the court. The landlord wins the case, but he still can't kick out the tenant. He has to file again. Another one is called the writ of possession, which gives the sheriff the right to evict the tenant. Now, the tenant's possession is, the tenant, meanwhile, the landlord can store the tenant's possession for 30 days, and he can sell that to cover any proceeds that he has lost through the rent loss. Novation, I put that in just so that it can make sense. It's just a word, that's all. And what it means is that if in the meantime he actually finds another tenant or something else, he draws up a new lease, and the new tenant is called a novation. It's a document, novation. Now, let's say that the landlord, the lessor, gets mad and turns off the electricity or whatever. The tenant can actually sue the landlord for covenant of quiet enjoyment. And the tenant can stay there, indefinitely. So the landlord really has to be up to date with the maintenance of the property. If not, then the tenant can sue the landlord. Finally, we're on the subject of assignment and sublease. How does this all work with this landlord-tenant stuff? So we have an assignment. So assignment works like this, right here. The lessor leases out to lessee A. Lessee A assigns a lease to assignee B. So let me give you an example how that works, and then I'll ask you the next question. How it works is that, let's say you have a business, and you have a 5-year lease with 3 years to go, and your business is really bad. You want to get out. You can't because you have a lease. So what you do is that you find someone to take over the property, the assignee B. Assignee B will pay the lessor directly. The lessee is out of the picture. Okay? Now let's go over here then. Sublease. So here's how it works with sublease. I'm going to bring that up a little bit. Sublease like this. You have a lessor leases to lessee A, who subleases to sublessee B. Okay? Sublessee B pays lessee A. Lessee A pays lessor in that sense. So, example would be, you have a business. You're doing pretty good, but you still want to make a little bit more money. So on the corner of your office, you decide to sublease that. You're still in the building. You still are obligated for the lease. So you sublease him for a little bit more money, but the sublessee pays you, the lessee A, and the lessee A pays the lessor. The question on the state exam is, who is liable if someone's late? So here it is. If let's say the assignee does not pay the rent, who is liable? The assignee. Okay, it's whoever really directly pays the lessor. Now under the sublease, who is liable? It's not the sublessee, it's the lessee A, because the lessee A pays directly to the lessor. So lessee A is liable. Well, this ends the chapter on assignment and sublease.